Hello, beautiful people. Happy Monday to you guys. It's already afternoon. The morning just has flown by so quickly. Morning, everyone. Morning, Facebookers. Morning, Instagrammers. I'm so excited. I started coming on Instagram Live. Instagrammers are just amazing. I love the vibe, the energy, their presence. They're just, very, very alert. I love it, love it, love it, love it. Okay, morning, guys. Well, afternoon. So today we're going to do a quick one because I have to hop off and join a Zoom call very shortly. I'll tell you all about that Zoom call later. It's something very exciting happening at this law firm, Poku Law. As you guys know, we're a fabulous immigration law firm serving immigrants around the United States. And there's been a latest update just this month, February 2022, a few days ago. I've done multiple videos discussing VAWA with you all. It's the abuse green card, as you guys know. And if you're looking for more information on that, please don't forget to, look up my videos, VAWA, abuse green card, Poku Law, and you will find the information. Okay. So I'm just going to jump right into it and let's get started. Okay, so I'm sharing my screen with Facebook as I've highlighted the relevant portions, but I'll still be telling all the Instagrammers what's going on here. Facebook, as you guys are welcome. I've neglected you guys because, just because Instagrammers are like a real vibe. Well, Facebook too, so don't worry, don't mind me. Okay, so what is VAWA? VAWA is pretty much an abuse green card, right? And it just gives victims of domestic violence a green card if they are foreigners and if the abuse is meted out to them or they suffer the abuse at the hands of qualifying relatives who are either U.S. citizens or green card holders. Then the abused victims can file a self-petition, which is known as VAWA. Okay, so VAWA was actually enacted in 1994. And so pretty much, as I said, it provides certain non-citizen family members of abusive U.S. citizens and abusive green card holders or lawful permanent residents the ability to self-petition to become green card holders or for immigrant classification. And this process can happen without the abusers knowing that these petitions are being filed against them. Well, it's not really against them, but using the experiences that these foreigners have suffered at their hands. The abusers do not have to know and will usually have no or zero knowledge about the process. So it's a very safe process. And the VAWA, the Violence Against Women Act of 1994, what it seeks to do is to remove the dependence of dependence on the abusive U.S. citizen or LPR family member to obtain immigration status. So they don't want the abuse victims to depend on these abusive U.S. citizens or green card holders just to be able to obtain immigration status. And it allows the victims, the non-citizen victims, to save both safety and independence from the abuser. Okay, so that sums up what VAWA is and what the objective of VAWA is. Okay, now let's just jump into it. This policy update, we're going to discuss just an aspect of this policy update. I have something happening here, so I hope I'm not talking. You guys, I sound very audible. My speech is a little muffled because I have some pain here, but I hope it's not interfering with the way I'm communicating, and you guys can hear me very well. If you cannot hear me, don't hesitate to let me know, and then I will try to speak up more clearly. Okay, so this let me tell you guys, this policy alert was released on February 10th, 2022. I'm just getting around to trying to do a live video. It's sometimes life gets busy. So, but of course, assisting immigrants, helping them and advocating for them. So it's a little delayed, but specifically this, this guidance is for purpose. And we're going to discuss what the policy update, the focus of this video will be on this main the crux of this guidance. So specifically, this guidance has actually changed the way immigration, USCIS, is interpreting the residence rule under VAWA. Okay. In the past, what they were doing was that, if you want to prove that you've been abused by a green card holder or a US citizen, you had to prove that you shared residence with them during the abuse. Okay. However, US immigration has realized that their interpretation of this rule was wrong. The USCIS, US immigration, interpreted this rule very narrowly, and now when you take a look at the statute itself, they were actually misinterpreting the law. They interpreted it more narrowly than the statute actually required. We'll go into the statute, hopefully, if we have time. But now the latest update from case law is that you do not have to share residence with your abuser during the abuse. You could have resided with the abuser at any point in time in the past. Okay, regardless of whether the abuse did not happen during the time you lived with them or not. Okay, so I hope you guys see the difference. Let me read this and then I'll try to explain it again one more time using very simple language. So specifically, this guidance changes the interpretation of the requirements for shared residence. So there's still shared residence. That rule has not changed. The abuser is still required to demonstrate that they have shared residence with the abused. Well, the abuser and the abused. It's the abused that is required to demonstrate that they have shared a home or have lived in one place with the abuser. Okay, so the self-petitioner, so now USCIS no longer requires self-petitioners to currently reside or to have resided in the past with the abuser during the qualifying spousal or parent-child relationship. Okay, so let me rephrase this. So the new rule is that you're not required to have resided in the past with the abuser during the qualifying relationship. So for example, let me give an example. If you are married to a US citizen and he abused you and you guys got married, but you never lived together during the pendency of your marriage. However, you lived together in the past, maybe the time you guys were dating, right? That actually meets the new policy guidance. Okay, so the thing is that USCIS is no longer requiring self-petitioners to currently reside or to have resided in the past with the abuser during the qualifying relationship. Okay, so that's the catch. Then the interpretation is pretty simple. You are no longer required to have lived with your abuser during the qualifying parent-child or during the qualifying spousal relationship. You could have lived with them even when you guys were not in a qualifying relationship, but then you will satisfy the shared residence rule for the purposes of VAWA fully and squarely. Okay, so I hope that makes sense. You are no longer required as a self-petitioner to currently reside or to have resided in the past with the abuser during the qualifying relationship. So you could have resided with the abuser before the qualifying relationship was established, or perhaps even after the qualifying relationship was established, because it just says that it no longer requires that. Let me actually read. Let's see if I'll be able to pull up the statutes, and then we can clarify the information on whether you can live with them after the qualifying relationship. Okay, so right here it says again, the policy highlights. It changes the interpretation of the requirement for shared residence to occur during the qualifying relationship, and instead, it simply requires the self-petitioner to reside or have resided with the abuser at any time in the past. Okay, so that clarifies it for us. So now you no longer are required as an abused victim to currently reside or to have resided during the qualifying relationship, but you should have resided with the abuser either in the past when the relationship wasn't even established or currently. Okay, so of course it's not after the abuse has happened. the interpretation seems to just cover in the past and currently, and even before the qualifying relationship. Okay, so I believe that clarifies it. As time goes on and as they, adjudicate more cases under this, the rule will become clearer with more examples, and then we will look at the limits. We'll be able to, ascertain the limits of the rule and what they specifically mean, because sometimes the rules, they may be clear, they may not be ambiguous, but it's actually um in applying, in the application of the rule, that we understand it better. So this is the latest policy guidance. It just means what it means. I hope you guys understood it. Let me see if I'll be able to pull up another thing here that I was looking at during the weekend. Okay. Oh, once I leave, did I? Okay, I think it's still sharing. Let me see if the screen is still sharing. Perfect. Good. I love this. Okay, I was able to pull up the statute. So we're going to look at the specific statute. When you look at the INA, okay, no, this is not the INA. This is the 8 USC section 115, procedure for granting immigrant status. That's the portion that codifies the, the VAWA self-petition. Let me see if I will find it here. Guys, you may drop me your comments and then I'll read them soon. Okay. So I'll just look at, for the purposes of a marriage, okay, if you're in an abusive marriage, what the statute says. It says that just under this subsection DD, it says who has well, let me see. For the purposes of subclause 1, an alien described in this paragraph is an alien who is a spouse of a lawful permanent resident of the U.S., who believed that he had married a lawful permanent resident of the U.S., all of that, who was in a bona fide relationship. This is for green card holders, all of that, who's a person of good moral character. If you're a self-petitioner, you have to be of good moral character. You're eligible to be classified as a spouse. And then DD says who has resided with the alien's spouse or intended spouse. Okay, so it just simply means that you should have resided with the. So that's the statute that talks about the residency rule. Let me see if I can find another subsection here. Okay, well, the statute is clear. You've resided with the alien spouse or intended spouse. So you it's just the residency rule, the residence requirement. You should have resided. And so what they are interpreting this to mean is that the residency rule is no longer required to be during the qualifying relationship. It could have been any time in the past, even before the qualifying relationship was established. I hope this is clear. Remember that VAWA, parents can file VAWA if you feel like your child has abused you, or for example, or again, married people, if you feel like your married person has abused you and it rises to the level of extreme cruelty and battery, then you can file VAWA. And that's the elucidation or the clarification on the residency requirement. It's not necessary that this should have been formed during the pendency. It's not necessary that the residency requirement, it's not necessary that the abuser and the abused actually share the residence during the qualifying relationship. Okay, so I hope that clarifies it. Well, thank you so much, guys, for watching. Let me read a few comments on Facebook. Mr. Francis Gavin says, hi, hello. He says, we are cool. Okay, thank you for watching. Mr. Francis Gavin says, so what is a qualifying relationship? So if you are the spouse of a U.S. citizen or a green card holder, or you are there's a parent-child relationship and the abuser is a green card holder or a U.S. citizen. Okay, and then we have, is verbal abuse part of the abuse? Yes, it's certainly part of the abuse. If it rises to the level of extreme cruelty and battery, then it's certainly part of it. All right, guys, I hope you guys benefited from this video. If you need my help, don't hesitate to call us and we will be very happy to assist you guys. Our phone number is 802-7800-564, website akpokulaw.com, akpokulaw.com. Guys, we released our latest ebook during the 2/22/22. It's free, it's red flag or green card. Just go onto my all our social media pages and click on the link. If you're on Instagram, on our bio, it's the first. If you're on Facebook, I believe our last post before this, you'll be able to download the ebook for free. Okay, read it and share feedback with us. We'll be very excited to hear back from you. All right, people. So thank you so much for joining. I'll see you guys soon. Please take care and stay safe. And of course, we represent clients all around the US in all US immigration matters. I'm very excited to have come your way, but we'll call it a day and I will see you soon. Human's Law. Hello, girl. I hope you're doing good. Well, thank you all for joining. Abenofe, fellow counsel. I hope you are good. Excellent believer. Very excited that you guys are all here. Okay, guys, take care. I'm off.